we have Mr. Lodewijk van ZWIETEN, who is a Dutch national prosecutor for cybercrime, extensive experience in taking down different botnets. Examples are here, Bredolab and Diginotter. I don't know if you were doing the takedown yourself or you were
Absolutely.
Absolutely. Yeah. And together with Mr. Geert from the Federal Prosecutor's Office of Belgium, who is focusing in his work on cybercrime targeting nations' critical ICT infrastructure. Very glad to have you here, and very glad to have you presenting what I hope to be examples of your actual practical experience from these cases, and already having you two on stage is an example of international cooperation. So, thank you for coming.
Thank you. Thank you very much. Thank you for giving the floor to the last two members of the boys band who will give a joint presentation. You will immediately see a difference in style. I'm more the static type behind the stand. Lodewijk is more of the dancing type. He will run around across the stage, but it's just a difference in style. We are basically doing the same thing. We are both national prosecutors responsible for cybercrime, each for our own country. That would be Belgium, and Lodewijk, it's the Netherlands. What we would like to do here is try to give you a taste of the current situation of the fight against cybercrime in an international context. The things that are evolving right now, we would like to give some recommendations to improve the effective cooperation. And we will try to illustrate this with one or two cases we had jointly. But first of all, before we do so, let's start with the bad news. And that is, let's have a quick look at how, in general, in criminal law, international cooperation traditionally operates. And that's what we have called here with a trendy cyber terminology, International Cooperation 1.0. As already explained by Ian in the first presentation, let's start at the bottom left. There is a local prosecutor in a country who has power to investigate and to prosecute cybercrime. But of course, these state powers, part of these state powers that he got are only valid for his own state. If a criminal investigation stretches beyond the borders of the state, he has to respect, of course, the sovereignty of the other state. He just can't go in the other state and collect the information. We have to respect their jurisdiction over their own territory. So the investigation turns into a diplomatic issue between states. We will have to ask politely if they are ready and prepared to execute our request. So how does this take place in reality, in practice? We send out a formal letter of request, an LOR or an MLA request, mutual legal assistance request. It's paperwork. We have to describe the facts of the case, the results of the investigation until now, the crimes that have been committed, and the measures we are requesting. And we will send this into our own hierarchy to our Ministry of Justice that will send through the request to the Ministry of Foreign Affairs. They will add a lot of stamps and extra signatures. They will accompany the request with an undertaking of reciprocity, which means it's a solemn pledge that in return, if they ever had a question in the same situation, we will execute their request. This letter will be sent to the Foreign Ministry of Foreign Affairs and sent through the Foreign Ministry of Justice. They will assess if there are any political or diplomatic repercussions in executing this request. If not, they will send it through to the desk of a foreign prosecutor who will put it on the pile of letters of request he has received from all over the world and start working on it whenever he has the time. I don't have to explain to you, with the words of Ian, it's a painfully slow process, certainly in the area of cybercrime. Of course, there are shortcuts. There are multilateral and bilateral treaties which are simplifying the process. For example, within the EU, we can send our letters of request directly between judicial authorities. But the problem stays the same. It ends up with a foreign prosecutor whom we don't know and who will take the time whenever he has the time to execute the request. So it can still take months, highly insufficient to tackle modern cybercrime effectively. Why is that? Because, and I don't think I'm telling a lot of new things here, in cybercrime you practically always need some kind of international cooperation. Cybercrime is transnational. Cybercrime ignores, it transcends borders and territories with the greatest ease. Criminals and/or victims in a case are spread across the world, and if they're not, their infrastructure they are using, the services they are using are spread across the world. I refer to service providers who are working across the globe, who are situated, have their seat at the other side of the world, but are working on a global scale. Secondly, in cybercrime we need a dedicated international cooperation, because cybercrime is complex, it's technical. For domestic investigations, you need dedicated prosecutors who have the knowledge, the skills, and who are interested in the matter. Equally so, when you have when you need international cooperation, you need equally dedicated counterparts at the other side of the border. And thirdly, we need the cooperation to be executed expeditiously, because electronic evidence is very volatile. It is only there for law enforcement and for the prosecution for just a few weeks, a few months perhaps, sometimes even only a few days. So we have to be fast. As you know probably, in Europe currently there is a huge debate going on the issue of data retention. How long can we ask a service provider to keep data on their customers' activities on the internet? This discussion is going on because, of course, there are issues of privacy connected with the storage of data. But on top of this debate, lately, the last few years, came the revelations by Snowden, the techniques of mass surveillance which were exposed. So I can tell you one thing. Law enforcement currently seems to become the big loser in this debate. I explain myself. In Europe, we had a data retention directive, which tried to harmonize legislation among the European member states by providing a data retention period between 6 months and 24 months. This data retention directive has been rendered invalid by the European Court of Justice. And what we have seen in some member states, is what I would call almost a hysterical reaction to that decision by the European Court of Justice. In many member states, their own data retention legislation, though it was not based on the directive, was abolished, was suspended, which means that in some states we don't have any data retention at all. And for the sake of privacy, service providers sometimes are even compelled to destroy this evidence as soon as they no longer need it during their activities, which brings cybercrime, in my opinion, to what is one of the only areas in crime where we compel witnesses, victims, future victims, to destroy voluntarily evidence which might be interesting in future cybercrime cases. So this all means that there is room for improvement.
Yes, room for improvement. Absolutely. Like Geert said, we run the risk of becoming the losers in this fight against cybercrime as law enforcement. However sympathetic I am to your plea, Ian, that obviously the long arm of the law shouldn't extend to the length of the sleeve that fits. It shouldn't extend their reach. Now, we as prosecutors, at least us two, we don't like losing. We're dedicated, we're committed, and we like winning. Well, yes, we like winning, we just don't like losing anyway. And the Global Conference on Cyberspace, which took place over a month ago in The Hague, was for us as good an opportunity as any to see if we could develop some winning strategies, see how we could really further the game against the fight against cybercrime. So during that week, the GCCS was on Thursday and Friday, and on the Wednesday before that, Dutch Prosecution Service and Dutch Police organized their own conference, the Law Enforcement and Prosecutors Conference, or LEAP, to give it an acronym, in which we invited representatives from a law enforcement community and from prosecution service from all over the world. Invitations were sent to all continents, and eventually 26 countries from all over the world came to The Hague. They were invited to join the GCCS afterwards, so that was a nice incentive to talk about what we could do, not just pine about what challenges we had, not just wallow in our misery, but just try to formulate concrete steps ahead that we could present. We could have presented at the GCCS, so we had a very nice platform to present these recommendations, and that would encompass recommendations both regarding international cooperation and an integrated approach. And on both those topics, we developed both recommendations of a more legal nature and recommendations of a more operational nature. Now, what you will find is that we did not give any recommendations about the current threat landscape and about how that is evolving. We have our ideas. If there's questions, if there's room in the Q&A, we can tell you a little bit about that, because that threat landscape is changing rapidly, and it is heavily impacting the way that law enforcement needs to do its job. What we like to do now is to present you a number of these recommendations very swiftly, because there are quite a lot, and in the process give you a bit of an example of how we, at least from a European perspective, have some good practices, and we learn some good practices from our colleagues all over the world and try to integrate it into a full set of recommendations.
In the context of international cooperation, we quickly discovered that there are some recommendations to be made, not to ourselves prosecutors, but there are some legal recommendations to be made and to be addressed, not to politics, to the legislature, because some issues, some compelling issues, have to be addressed in order to get forward. And we listed here some of these issues. Most of them have already been treated. Jurisdiction in cyberspace, the problem of loss of location. Ian talked to us about it. Location is getting more and more an irrelevant criterion, in my view. The storage of data spread with cloud services over thousands of servers, where the eventual location of data is not the result of a deliberate process, but depends on the use of algorithms. It has all been explained by Ian. Question is, shouldn't we think about a new criterion, a new way to define the aspect of jurisdiction, not link it to territory, not link it to location, but search for other criteria. What I would like to talk about is about what we experience in our day-to-day practice as a consequence of the lack of addressing these legal challenges. And they've also already been touched on by Ian. We feel this problem as being very cumbersome in our relations with service providers. There too, there is the jurisdictional question. Which country can ask information to a service provider? Who will issue the production order in order to get information from a service provider? Will that be the country where the service provider is established, the country of residence of the service provider? Will it, on the other hand, be the country where they have stored their information, the country of the server? Or could it be every country where the service provider is economically active, which would mean that one service provider would have to comply with demands of many countries, all countries where he is economically active. What we see here is that the lack of a clear answer to this problem leads to the conclusion that it's the service providers themselves that decide, that dictate if and how a specific country can get its information. And it became very obvious when we were confronted a few months ago with a sudden change in policy by certain service providers following the revelations, the Snowden revelations of mass surveillance by NSA. And we saw that certain service providers, for commercial reasons, for fear of loss of non-US customers, made clear to their customers that their data will not be stored within the USA, will be stored elsewhere, and will be out of reach of NSA. And we saw this, for example, in a change of policy with Yahoo and Microsoft overnight. Suddenly, for our traditionally we always sent an MLA request to the United States, and suddenly Yahoo decided, informed us, notified us of the fact that we no longer had to go to the US, but had to go to Ireland, to their Irish subsidiary for information regarding to their non-US European customers. Microsoft, slightly different. They explained to us that it will be the country where the server is located that will be the country that has to be contacted. So which means that we have to send a preliminary request to Microsoft to ask them, where is the data? Where is the server located? And in return, send then the letter of request to that specific country. The bottom line in this story is that it's the service providers that determine for us who can claim jurisdiction to ask data or not. And as mentioned by Ian, even the US themselves are confronted with this change of policy. They are currently before court against Microsoft to get information which is stored outside of the US. So we need a solid legal framework. We're in desperate need of a solid legal framework. I'm afraid it won't be there in the next few years. In meanwhile, another recommendation by LEAP is that we should involve as early as possible the prosecution service into criminal investigation in cybercrime to address, to detect as early as possible all these legal challenges, because it's up to the prosecution to go to what Ian called the ultimate arbiter. We will have to defend the case before the judge, so it's best that we get in as early as possible in the investigation to check if everything goes as we would like.
Absolutely, totally concur, and we've had very good experiences with that. What we don't have very good experiences with is the difference in terminology that still exists. Even though we have the Budapest Convention, which offers us, I think, a host of very usable terminology, in practice we see that even countries that have ratified the Budapest Convention don't copy that terminology. For instance, what is a computer system might differ in a country. What characteristics you are to expect from a computer system to have the law be applicable might differ in certain countries. And even outside of the Budapest Convention, what is cybercrime? I mean, we have cybercrime, we have high-tech crime, we have IT-facilitated crime, we have e-crime, and we all mean different things by that. Now, in the Netherlands, we have a very narrow definition. So for us, it's not every crime that has a power cable attached to it. No, for us, it's those crimes that cannot exist without IT and the internet. New crimes, new tools. Not so in other countries that have a much broader definition. It's important to streamline terminology, to know exactly what we're talking about, to have the same picture in our head when we talk about cybercrime. So perhaps it's not a bad idea to see if we can work on a sort of international lexicon for law enforcement. Perhaps that would help.
Okay. Another recommendation, a very important one, is that we should invest heavily on advancing the level of expertise within police forces and within prosecution, even within judiciary, but of course that's out of our field. advance the level of expertise on cybercrime, because cybercrime is of course becoming a day-to-day concern for every policeman, also even the policeman on the street. And it's not an exceptional thing anymore that's only there for a few specialized nerds like both of us. So there is a long-term investment requested in every country. And there is an important aspect also on an international level. I think we think that international institutions can play an important role to advance this level internationally. Mm-hmm. And we have made a list here of some institutions which could play an important role in this area. International Association of Prosecutors and Eurojust could be important drivers in this story for prosecution. As far as police is concerned, Interpol, Europol, CEPOL, it's the European Police Academy, ENISA, ERA, etc. all have programs, training programs available. It should be interesting to compare them all, see if they all say the same things, and it could be important catalysts to improve the level of expertise in several countries, also countries which are origin of cybercrime or destination of cybercrime, but which don't have the level of expertise needed to tackle these forms of cybercrime. Next to the capability building, of course, it's also a good opportunity to build networks of practitioners during these meetings.
Absolutely, and that somewhat automatically leads to specialized international regional cooperation. We've heard a bit about how it's organized in Africa. For Europe, we have the European Cybercrime Center at Europol. On an international level, we have the IGCI in Singapore, which has just started. Perhaps you may have heard of JCAT, which is a joint action, a joint cybercrime action task force that is hosted within Europol, but is in itself a cooperation between some 13 countries and organizations working together to fight cybercrime. The National Cyber Forensics and Training Alliance in the US, which is a specialized national corporation actually for the United States. And then we have on a European regional scale, we're currently together with Eurojust sampling the possibilities to set up an EU network of cybercrime specialist prosecutors, which we don't have, and which is weird because for ages, obviously, the police have had very well-connected networks. They know one another, not so when it comes to cybercrime prosecutors. I'm meeting new colleagues every day, and this is weird because I've been working in this field for the last 7 years. And you could even take an example from fusion centers like they exist in the United States, which enable sharing of information between government bodies, and which, at least from a law enforcement perspective, help us to make the right choices, make the smart choices based on the information that is out there. I will put it to you, Geert. This was not planned, but because of the time, we have like 7 minutes left. If we should move the black shades part to the end of the presentation?
Yeah, okay. That's okay.
Would you mind?
Yeah, no, okay.
This was not rehearsed at all, but I would think it would be a waste not to at least show you the recommendations that we drafted at the LEAP conference. You've probably heard about the Black Shades investigation. This was a good example of not just a regional but a global cooperation against cybercrime, which in itself took like a year to set up. But created such a model for cooperation that a follow-up operation, Animus, which had a different goal, was executed with only 3 months of preparation. So that shows how fast the ball can get rolling. I will just go very fast through these slides, and we'll get back to them, obviously, Geert. Now then we come to the recommendations regarding the integrated approach, an integrated or network-centric approach. Obviously, as networked, as decentralized as the internet is, law enforcement could be more effective if it works from a network-centric approach. So some legal issues that we've been running into: the information exchange between private partners. Even if you have a working public-private partnerships, privacy laws dictate what information may be shared and may not be shared. Obviously, human rights issues play in general a role in what information can be shared, and especially what can be done with that information. But it's an issue that should be addressed. Privacy laws are somewhat different. On a regional basis, you may have some more generic privacy laws, but on the whole, on a global scale, things are widely different. As is the case with how we go about international cooperation with countries that we haven't worked with before, countries that we don't have treaties with. But perhaps if I wanted to work with a country that the Netherlands didn't have any dealings with, but Geert had, and he had an MOU with the law enforcement officials in that country, why couldn't he share that with me, so I could just basically copy-paste it, replace Belgium with the Netherlands, and then I would have an MOU that I would know the other country could possibly sign very easily. The same with model legislation, like is the case with the regional organizations in Africa, which is a very good practice, obviously, to make sure that we find the same things punishable, and that we have the same toolbox when it comes to special powers of investigation. So on the whole, use good and best existing legal practices to further the development of the legal frameworks. Obviously, this has been going on. This is already a process that has been going on for a number of years. We felt that as practitioners, we should chime in because we hadn't chimed in up until now, and we feel we have some very strong arguments. Now then, to operational recommendations. In a network-centric approach, the fight against cybercrime, law enforcement is a tool under the execution of an existing cybersecurity strategy. That might be a regional strategy, it might be a national strategy. It's just a good idea to have a strategy and to make sure how law enforcement plays a role in that. And make sure, at least that's what we think is a good practice, make sure that you stop chasing ambulances. Don't expend all your capacity today on an incident going on there, and then tomorrow when there's an incident over there, pack up your bags and go all the way over there. Make sure that you think about it beforehand. What are the cases that we want to prioritize? What are the types of crime that we think are really so disruptive that we need to focus our energy on that? I know this might be different with countries that have a legal tradition of legality, but even in those countries, I'm very much aware that there are more possibilities than you might think from the outset to not investigate certain cases. We need to try to get from an incident-driven approach to a more strategy-driven approach, and we need to further the use of public-private partnership and JITs as tools to establish that. So what you will have, or what you will hopefully get, is this process, which will not go away anytime soon. It's good that it's there. It makes sure that the court can see everything that we've done and find it in accordance with law and international law, but make sure that we add this. Make sure that we add direct contacts. Make sure that we find one another in our networks, that we make use of public-private partnerships, that perhaps fusion centers play a role. Basically, just create your peering partners, create your networks, create your cooperations that will help you gaining the traction that we need to gain, and gaining more speed than we could get from the other model. Now, that is basically the extent of the recommendations. I'll leave it to you, Anne-Marie, if we've still time for black shades, or if we take questions.
Take questions first.
We take questions. Anyone interested in the black shades case, come and visit us afterwards, because we have some very interesting slides about that.
Refer to the slides
on
themselves.
Yeah,
They're quite explanatory, self-explanatory.
We are a bit over time, but let's take one question.
Okay.
Yes, here in front. Can we get the microphone here, please?
Hello, good afternoon. LTC Maurizio D'Urso, Italian Defense General Staff. And thank you for the impressive presentations. And but I would ask you to Mr. Lodewijk, the prosecutor, the Dutch prosecutor, about a proposal, a law proposal of the 2nd of May 2013, a proposal made by your Ministry of Justice.
Several proposals that day, but
no, if it has become a law, because I don't know, maybe you know this proposal, and this proposal authorizes the prosecutor, the Dutch prosecutor, in the cases regarding major crime offenses like pedopornography, to hacker inside, to authorize the hacking inside the computer, to collect evidences, to collect photos, and to let the pictures become inaccessible to the public. And it seems to me that this could be done elsewhere the computer is, even abroad, elsewhere in the world. So it's a breach to the wall of domestic borders. And means to overcoming the necessity, the need of strict cooperation between states.
Okay, very briefly, if I can, with such a topic. You are referring to the proposal by the Dutch Minister of Justice to allow law enforcement to remotely access a computer system, to then, once they've remotely accessed it, either secure data, make data inaccessible, perform prolonged surveillance, intercept communications and whatnot. Okay, this is obviously a highly controversial subject, which we also agree to as prosecutors. Now, it is, at least in my perspective, and I've urged the legislator to remedy that, a misconception that that law will allow Dutch law enforcement to hack abroad, to remotely access computer systems abroad. Why is that a misconception? Because I feel, Geert thinks differently, but I feel that no country can unilaterally grant itself enforcement legislation outside their own territory without a solid basis in international law. Okay, so for me the situation is quite simple. Either you can or you cannot geolocate a computer system. I don't think there's anything in between. It would be weird to be able to say, well, I know for certain that this computer system is located outside of the Netherlands, but I don't know where it is, where in the world it actually is. It's either you can or you can't. So if you can locate a computer system, it's quite easy. If it's outside your territory, you need to resort to the mutual legal assistance system, which is something that we definitely want to adhere by. If you don't have the capability to reasonably ascertain the physical location of the system, and by reasonably I mean that of course you have to do a minimum investigation. to try and see within the given time frame, within your capabilities, where that computer system is located. But it might be that it's just not possible, either technically, well, but at least it's not feasible within the constraints of the investigation. Now, from a Dutch perspective, we have argued that for certain types of crimes that create that fall within what we lawyers call the principle of ubiquity. It might be that crimes that have their effect in the Netherlands or that make use of Dutch infrastructure fall within the scope of the Dutch law. The Dutch criminal law is applicable to crimes that have their effect or that use criminal infrastructure. And from that, I think, and that's a legal practice which we've put before the court, and the court has found it very much okay. We think that from that principle of ubiquity derives some form of enforcement jurisdiction, insofar as that under certain circumstances, if there are no indications to the contrary, I think it is reasonable to assume that a computer system is within your territory, at least up until the point where it's certain that it does not. The other way to go about it would be to demand that you ascertain the physical location, and that you can only have enforcement legality once you have established the location. Now, in situations where you simply cannot establish the location, that would result in impunity, and that is something that we as prosecutors do not like very much, because it would mean losing. We don't like losing. So this is a legal. Well, how do I say that? This is a legal theorem that we've developed in practice. It does not mean that the law allows us explicitly to go abroad, like the Belgian law does. There is a provision there. Geert,
you go much further than I.
Geert knows everything about that, but I think the internet, loss of location, stuff like that, at one point or another, is it so unreasonable to act under certain assumptions as long as you formulate very clear prerequisites before you can act under that assumption? I don't think that's unreasonable, but I'm sure that I'll have, I hope to have many talks with Ian about that, because I'm sure he's interested in that. I hope it kind of answers your question for now.
Well, you definitely hit the his sweet spot here.
I do, yeah.
So
how much time do we have?
None.
None.
So thank you again. It's very interesting topics, especially the question that was raised in the end. I wish we had more time. We don't, unfortunately. I wish that next time you're taking down a botnet or doing something like this, you would be drinking coffee from these mugs. So thanks again.
All right, thank you.
Thank you.